Hello and welcome to Quick Revision series. Today we are tackling one of the most foundational articles of the Indian Constitution, Article 13. This article is often called the guardian or shield of our fundamental rights, as it establishes the supremacy of these rights over all other laws. It's the constitutional basis for the power of judicial review. In this session, we will explore what Article 13 says, the crucial legal doctrines it has given rise to, its complex relationship with constitutional amendments, and how it led to the landmark Basic Structure Doctrine. Let's begin. So what exactly does Article 13 state? It's divided into key clauses. Clause 1 deals with pre-constitutional laws, laws made before the Constitution came into effect on January 26, 1950. It says any such law, if it's inconsistent with fundamental rights, become void to the extent of that inconsistency. Clause 2 is forward-looking. It prohibits the state, that is, the government and legislature, from making any law that takes away or abridges fundamental rights. Any law made in contravention of this clause is void from the very beginning. Now, a critical question is, what does the Constitution consider a law for the purpose of Article 13? Clause 3 provides an inclusive definition. It clarifies that law includes not just legislation passed by Parliament or state legislatures, but also any ordinance, order, bylaw, rule, regulation, or notification. It even includes custom or usage having the force of law. This wide definition ensures that no arm of the state can violate fundamental rights, even through executive action. From Article 13, the Supreme Court has evolved two very important doctrines. First is a doctrine of severability. This means if only a part of a law violates fundamental rights, the court will try to sever or separate that bad part. If that bad part can be removed without destroying the law's main purpose, only that part is declared void, and the rest of the law survives. Second is the doctrine of Eclipse. This applies to pre-constitutional laws. It says that an old law that violates a fundamental right isn't dead, but just eclipsed or overshadowed by the fundamental right. If the fundamental right is later amended to remove the conflict, the old law can become active again without needing to be reenacted. This is where the biggest constitutional battle began. The question was, is a constitutional amendment passed under Article 368 also a law under Article 13 Clause 2? If yes, then no amendment could ever take away a fundamental right. Initially, in the Shankari Prasad case 1951, the Supreme Court said, no, an amendment is not a law and is outside Article 13's reach. However, in the Golaknath case of 1967, the court reversed this. It held that an amendment is a law and Parliament cannot curtail fundamental rights, even via an amendment. This tug-of-war between Parliament and the judiciary was finally settled in the historic Kesavananda Bharati case of 1973. The Supreme Court masterfully balanced the situation. It overturned the Golaknath ruling and upheld the 24th Amendment, confirming that Parliament does have the power to amend any part of the Constitution, including fundamental rights. However, it introduced a crucial limitation. Parliament cannot, in the process of amending, destroy the basic structure or fundamental features of the Constitution. Article 13 and the power of judicial review it contains is itself a part of the basic structure and cannot be taken away. Now, let's check your understanding with some quick practice questions. Follow for more such videos.